schedules to join us. So we have Senator Mark Pody, who represents this area, part of this area, part of Wilson County now in the Tennessee State Senate, and a longtime Wilson Countyan. Also proud to have with us Gallatin City Mayor Paige Brown, Sumner County Mayor John Isbell, and we then have a few folks, others that I'd like to mention. Corey Johns from the Wilson County Economic Development District. Happy to have with us President of the Tennessee Bankers Association, Colin Barrett, and a number of our bankers from the area, and we appreciate you all joining us today. And then we have from the Tennessee Credit Union League, Sarah Waters. I know I'm leaving out some folks that probably deserve mention, but thank you to all of our guests that are here today. And I hope you enjoy seeing a little bit of your Congress in action. One of the things that oftentimes folks are not familiar with, and I'll have to admit probably when I ran for Congress, I didn't have a complete appreciation for how important the oversight function of Congress is. But one of the things that we are charged with doing is a part of the constitutional construct that the founders gave us is to take a look at what the executive branch of government is doing and provide oversight that they are administering the laws and responsibilities that have been given to them through legislative action of the past. Make sure that those duties are being performed in an appropriate manner. And that's what today is about. So thank you, Chairman Huizenga, for bringing the committee here to the 6th District of Tennessee. And thank you to all of our guests. And thank you to our witnesses for taking time from your schedules to join us today. And I'll let you introduce our colleague.
Well, I appreciate that, John. And we know that there's a tremendous amount of work that goes into a hearing. I'm a former staffer myself. And I do want to take a moment and just say thank you to all of the staff, both your office staff, our professional staff from the committee, and others that are here, the recording studio that is here with us as well. It's hard enough to corral the cats called Congress in Washington, D.C., throw us out in the field, and it gets even more difficult and more challenging. So I know there's a lot of time and effort that's been put into this. And I should say that this is the first that I've been a part of post-COVID. Pre-COVID, we would do some field hearings like this. And the idea, and I know our committee has done a couple of them already, I believe 2 others, and the idea is to get out. It's to get literally out of Washington, D.C., into the rest of America, to bring some of those voices to the table. It is something that it's an official function. Both sides of the aisle, all members have been asked to be involved and to participate. And we're just pleased that those who were able to make it today came. So with that, how about Andy? Why don't you give us a welcome?
Well, good morning, everybody. John, Congressman Rose did the shout-outs, and, kind of on a personal note, before, because we're in John's district, and you can throw a rock and hit my district. Before being a member of Congress, I was a county executive, and I was got to be really involved in the county fair. And so when John reached in and took the county fair from me, the state fair, I was a little jealous, I'll be honest with you. It's a great facility. It's an honor to be here at this facility, and, for Wilson County to host the state fair. Really just an icon. Of course, the Wilson County Fair in and of itself is something to be marveled. So, but truly, we have Nebraska and Kentucky represented here. Of course, 2 Tennesseans and my buddy Zinga, the chairman. But again, it's an honor to be on the committee. What we've seen, what we'll talk about today, is really important, as we've seen these regulatory regimes come in and essentially function as members of Congress, as the body of Congress, by creating legislation and burdens by rulemaking. And with that, Mr. Chairman, thank you. I'll yield back.
Well, thank you. Now that we've got that to the side here, so I will bring us officially into order. So the Subcommittee on Oversight and Investigations will come to order, and without objection, the chair is authorized to declare a recess of the committee at any time. This hearing is entitled Victims of Regulatory Overreach, How the SEC's Climate Disclosure Rule Will Harm Americans. And without objection, all members will have 5 legislative days within which to submit extraneous materials to the chair for inclusion in the official record. So I am going to recognize myself now for 3 minutes to give an opening statement, and then I will also recognize both Mr. Rose and Mr. Ogles as well. So with that, today's hearing has been 2 years in the making. In a rush to appease the left, Gary Gensler, the chair of the Securities and Exchange Commission, proposed a nearly 500-page climate disclosure rule in 2022, which, by the SEC's own estimate, would cost companies billions of dollars to comply. And how did Chair Gensler respond? He doubled down on it. Chair Gensler ignored the warning from the Supreme Court, which ruled in West Virginia versus EPA that the EPA had exceeded its statutory authority, relying on ambiguity as constituting an implicit delegation from Congress. Chair Gensler ignored the warning from the Fifth Circuit Federal Court of Appeals, which ruled against a separate SEC finalized rule about share repurchase disclosure. In that opinion, the court rightfully held that the SEC acted arbitrarily and capriciously in violation of the Administrative Procedure Act when it failed to respond to petitioners' comments and failed to conduct proper cost-benefit analysis, close quote. And finally, Chair Gensler ignored his own Inspector General, who concluded that the SEC faced serious management and performance challenges, raising significant concerns that the agency was attempting to enact too many rules too quickly. And that has been a constant theme that we have heard, is the deluge of rules that have come at all sides and trying to sort through that. He has finalized nearly 36 rules, with more than 20 remaining to be finalized. The fast-paced rulemaking over the last 2 years has raised serious questions about how important Chair Gensler views the internal economic analysis conducted by his agency, if there is any. Last year, the subcommittee launched an investigation into the climate rule and the SEC's process to propose and finalize the rule. We've requested documents, conducted transcribed interviews of current SEC staff, and held multiple hearings about the SEC's work on this rule. In response to the committee's request, the SEC has flooded the committee staff with tens of thousands of pages of unresponsive documents and very few answers. You might ask, like what kind of documents? I'll give you one great example. My congratulations letter to the chairman, being appointed chairman, was one of those documents returned to us as being open and responsive. I had that one in the file already. Given his lack of cooperation and the content of the material turned over to the committee, I can only conclude that Chair Gensler does not really want us to see the flimsy basis on which he has crafted this rule. Additionally, the SEC's climate disclosure rule blatantly undermines the Commission's existing materiality standard. Under the principles-based materiality standard, a company must disclose information to prospective investors and shareholders so that they can make informed investment decisions. The SEC should not statutorily redefine the materiality standard to prescribe climate-related disclosures for all public companies, even when a reasonable investor would not find such information important to their investment and voting decisions. On Friday, just 9 days after the SEC finalized the climate disclosure rule, judges in the Fifth U.S. Circuit Court of Appeals granted a temporary stay. The court's decision signals the SEC's authority to develop, finalize, and implement a climate disclosure rule is in jeopardy. And let me conclude with this. In the 2 years since the climate disclosure rule was proposed, we have witnessed an unprecedented assault on our capital markets. The Commission finalized the climate rule despite no clear congressional authorization. Although Chair Gensler has repeatedly reminded the public he is not a, quote, climate regulator, which we do agree on, under his leadership, the SEC has strayed far from its clear statutory mission and certainly its historic traditional mission. Investors should know that the SEC's overreach will significantly hurt our economy while serving as a boon for special interest groups and far-left activists. Unless he radically alters this approach to our capital markets, Gary Gensler's legacy will be that of an overzealous bureaucrat who has repeatedly been reined in by the courts. I want to personally thank the members of the committee who traveled from their districts, who are being with us here this morning, and to the witnesses, thank you very much. We very much look forward to this, and I commend your willingness to be here with us this morning. So with that, I'd like to recognize Mr. Rose for a very generous 1 minute.
Thank you, Chairman Huizinga, for holding this hearing. And as far as I'm aware, this is the first time that the Financial Services Committee has held a hearing in Tennessee, and for that matter, in the 6th District of Tennessee. So very proud to have the committee here and to bring our work to Tennessee, where hopefully Tennesseans can see it firsthand. On March 6, 2024, the SEC finalized the climate disclosure rule, which will have, in my view, devastating impacts on business and families across America. In 2022, I led a bipartisan letter joined by Chair Huizinga and 116 other members of Congress urging the SEC to withdraw damaging language in the rule that would cripple, in my view, the agriculture industry across the country and small business as well, right here in Tennessee, but all across the United States. Today, I can confidently say that we have already secured a victory for farmers and small businesses across the country by forcing the SEC to remove the Scope 3 provisions of the proposed rule. And but our work is not done, and I will continue to speak out and stand up for this. Stand up against this regulatory regime until the rule is removed in its entirety. Chairman Huizinga already made mention of the touchstone of securities law since our securities laws were put in place in the 1930s, which has been materiality as the guiding light for disclosure. Fortunately, this rule, I think, departs from that in a way that will ultimately prove to be disadvantageous for American industry. Thank you, Chairman Huizinga, and I yield back.
The gentleman yields back, and with that, the gentleman from Tennessee, which I got to get more specific, Mr. Ogles, is recognized.
Again, welcome. We appreciate you all and witnesses for being here. Today we're going to hear about the SEC's climate-related disclosure rules, which play to the tune of the administration's obsession with the climate change religion, and that's what it's become, is a religion. Simply put, this rule will bully publicly traded companies into reporting environmental information that has no relevance to the financial concerns that matter to investors. Right now, businesses are scrambling to comply with what is a landmark shift in how companies report on climate-related metrics. It's not the SEC's role to demand irrelevant disclosures, much less to demand companies report on political and social issues. Our Constitution empowers only Congress to make the law, and importantly, to take responsibility for the consequences. As SEC Commissioner Hester Pierce stated, wading into non-economic issues involves trade-offs that only our nation's elected representatives have the authority and expertise to make. The SEC's power grab is unprecedented, and it's dangerous. This is a total overreach of power, and I look forward to working with my colleagues to nullify this rule. Mr. Chairman, I yield back.
Gentleman yields back. With that, I would like to recognize our witnesses and welcome their testimony. And I'll say this. Unfortunately, many stakeholders are, frankly, too nervous to testify and to speak out against the rule and the SEC and the process that's been going on. And frankly, some of that is fear of retaliation. That is very unfortunate. But again, I just want to underscore and say thank you to you all for your willingness to be here today. Today, we are going to welcome the testimony of Renee Jones. Ms. Jones is the co-owner of Jones and Church Farms, Incorporated, a now third-generation tomato farm, is my understanding in our conversation. Very much looking forward to hearing about your experience and what some of your fears are with what is coming down the pike. With that, we also have Mr. Alex Scott. Professor Scott is the Associate Professor of Supply Chain Management at the University of Tennessee, Knoxville. Now, we have a little bit of a connection. I actually have two. One that I didn't mention, I happen to have a niece who attends University of Tennessee, and she is finishing up her freshman year now. And he was also a former professor at Michigan State University. So apparently something about snow and climate was maybe ironically was part of what brought you down here. And with that, we have Whitney Hermendorfer. Ms. Hermendorfer is the Director of Strategic Litigation Unit at the Office of the Tennessee Attorney General, but she has also had a very long and amazing background and career in Washington, D.C. as well, and comes to this with extensive experience. So we thank you for your time being here today, and without objection, your written statements will be made part of the record. With that, Ms. Jones, you are now recognized for 5 minutes with your oral remarks. And we may have been noticing I've got a bit of a light gavel on this today. We do have a hard stop at 11:30, so we are hoping to use that full hour and a half. But with that, Ms. Jones.
Thank you. Good morning. My name is Renee Jones, and I'm a proud co-owner of Jones and Church Farms, which is a fresh market tomato farm in East Tennessee. Our farm started over 50 years ago with my father and my mother and their partners and family. And so we started with 50 acres. Today we are 3 generations, 650 acres of fresh market tomatoes, and 210 employees. I want to thank everyone who worked together to understand the impacts the SEC's proposed rule on climate-related disclosures would have had on agriculture and remove Scope 3 from the rule. The American Farm Bureau Federation, the SEC, and lawmakers on both sides of the political aisle worked with farmers to evaluate the repercussions of this proposal and responded in kind. And for that, we are truly grateful. Thank you, Chairman, Vice Chairman Rose, and all the members of the subcommittee here today for taking the time to come to Tennessee and to hear my story. I greatly appreciate having my voice heard on behalf of tomato growers in Tennessee. To comply with Scope 3, we would need to hire an attorney and a chemist to keep up with all that would have been required of us. Looking across the entire tomato supply chain, there are about 6,000 inputs in producing one tomato. On an average, our farm produces 38.5 million tomatoes in a 90-day season. It's a very perishable crop, and so we have a very short period of time to move it and to record all of the things that were being asked of us to record in Scope 3 would have been very costly. So from a records keeping standpoint, our farm would have had to have hired extra staff just to keep up with the data the SEC was asking for. Our profit margins are already very tight on our farm just based on the increased inflation of input costs. And so to afford these professional services of an attorney and a chemist and extra people to do the data recording would have tightened that margin, if not made it non-existent. To provide high-quality, safe, and affordable food to the nation and the world, we must comply with lots of government regulations from multiple federal agencies. These include and are not limited to the USDA, FDA, EPA, the DOL, and the IRS, just to name a few. Some examples are, first, our farm is we participate in the H-2A guest worker program, and that is regulated by the Department of Labor. They set our wages. We have no control over how our wages are set. They do this with an agricultural labor survey that is conducted annually, but it also includes the increases in the wages from the year before. So with that being said, in 23, our wages were increased by 82 cents an hour, and in 24, we're looking at a 92-cent raise an hour that we have no control over, and we don't find out about this till February of the year. We're going to be implementing those wages in April. So we have very little time to plan for that. Second is the FSMA rule, the Food Safety Modernization Act. We have that's a very labor-intensive regulation, but first and foremost, we all want to produce a safe, quality product for our consumers. So that is a priority. But over the last 10 years, these regulations and record-keeping items have increased threefold to our operations. So we're now we're taking weekly water samples. We are paying for 3 annual third-party audits, and we have 2 staff people that are dedicated to just food safety alone. Outside of existing regulations, there are also numerous proposed rules affecting our industry as well. One example is the EPA's proposal to impose restrictions on pesticide use. We're already under strict pesticide rules with the EPA, but now they're saying that before we can even apply any type of agriculture crop protectant, we must consult with the Fish and Wildlife Services. Again, just more burdensome regulations. Farmers are the best stewards of our land, and we produce products that provide food security for this country. And in return, we are burdened by overregulation from our own government. There are enough federal agencies dictating what happens on the farm. The SEC needs to stay on Wall Street and not on American farms. Moving forward, we look at California, and they are implementing similar requirements for companies doing business within their state. These consequences for agriculture are very negative as agriculture products come into that state via interstate commerce. California is not our nation's capital, and you all don't go there weekly to govern for the people, by the people. California should not be able to dictate what happens on any farm outside of the state of California, and neither should the SEC. I thank you for your opportunity to speak to you today and look forward to any comments or questions you may have.
Well said, and I appreciate that. Thank you. With that, we will go to Professor Scott.
Yes, thank you for the opportunity to testify about the SEC Climate Disclosure Rule. I'm an associate professor of supply chain management at the University of Tennessee, Knoxville, and I specialize in supply chain management, sustainability reporting, and understanding how such reporting rules affect companies across the entire supply chain. As with any complex rule or regulation, there are pros and cons to each. This rule has several potential drawbacks associated with it, which I'll list out. First, climate reporting will impose significant costs on businesses. These costs come in several forms. Companies will need to implement measuring and monitoring systems that, in many cases, do not currently exist. For example, consider a company that manufactures a product, distributes it through their supply chain, and delivers it to their end customer. The company will need to estimate emissions on the inbound side into the plant, the emissions associated with manufacturing the product, the emissions associated with loading the product and delivering it to the distribution center if it is on their truck. They will be required to measure the emissions as the product passes through their distribution center, including all of the touch points along the way. And finally, if the product is delivered on the company's truck to the final delivery point, they will have to estimate the emissions associated with that delivery, but not if they outsource that to another company, which creates potential undesirable incentives, which I will expound upon shortly. For many of the activities throughout the supply chain, there is not a standard technology or method to measure the emissions. For example, a leading organization for logistics emissions reporting, known as the Global Logistics Emissions Council, or GLEC, stated in their most recent reporting framework that, quote, the development of default emissions intensities for logistics hubs is still at a relatively early stage, unquote. Logistics hubs are also known as distribution centers that can be found in every major supply chain. And we do not have a good basic data on the emissions associated with them. Yet companies are required by this rule to measure their emissions when leading emissions organizations have difficulty generating default values on an industry-wide basis. And distribution centers are relatively simple operations. The problem is trickier when considering multi-stage globalized production settings where plants can have different energy sources and production methods. Second, there are several competing standards and a lack of clear guidance on the exact procedures that companies should follow when reporting emissions. For example, there are reporting standards provided by the Institute for Financial Reporting Standards, or IFRS, under the direction of a thing called the International Sustainability Standards Board, or the ISSB, the Greenhouse Gas Protocol, GLEC, and the International Standards Organization, also known as ISO, the European Union, the State of California, and the California Air Resources Board, known as CARB, and perhaps others. The IFRS, the ISSB, and GLEC standards do not prescribe exactly how to report emissions, but leave room for interpretation. For example, the ISSB standards use the word reasonable, without undue cost and effort, and faithful representation throughout their guidelines. This leaves room for flexibility, but can create confusion for businesses when determining what is reasonable or a faithful representation. Moreover, it invites potential lawsuits over these vague definitions. A third potential drawback of the rule is that it's not clear the exact value that the data will provide. While there is some truth to the statement that you cannot improve what you do not measure, there are few examples that I am aware of that demonstrate how governmental emissions reporting requirements result in significantly reduced emissions. Moreover, vague reporting requirements, which could ultimately be the subject of lawsuits, will require companies to devote resources to reporting as opposed to action, such as investing in cleaner equipment or funding environmental projects. Fourth, the SEC rule requires companies to report Scope 1 and Scope 2 emissions, i.e. those emissions that come from assets owned by the company, Scope 1 emissions, or purchased energy, Scope 2 emissions, but not Scope 3 emissions. Scope 3 emissions are those that are generated by suppliers and service providers for a focal company. These are often the largest source of emissions across the supply chain. I've seen estimates that Scope 3 emissions account for as much as 80 or 90% of the emissions in the entire supply chain of a product. This provides a direct incentive for a company to outsource their production and distribution to other companies, because doing so immediately reduces the Scope 1 and Scope 2 emissions of the focal company. However, this does not mean that the emissions were reduced, but merely recategorized into Scope 3 emissions. If the production or distribution method of the supplier is more pollution intensive than that of the focal company, then not only did emissions not decrease, but they could potentially increase. The SEC's rule, however, would show a reduction in Scope 1 and 2 emissions in this example. Thus, the rules would alter the make or buy calculation and result in companies buying more goods and services from third parties as opposed to providing their goods and services using their own assets. A further potential unintended consequence of the increased incentive to outsource is that many of the operations that companies currently control, large public companies that can often be influenced by consumers and government policies, will likely be shifted to companies that are not consumer-facing, more likely to be private, and possibly less influenced by government policy. Thus, the SEC rule could actually push emissions into places that are harder to observe and measure because they would become Scope 3 emissions of the large public companies. Lastly, as with any reporting burden placed upon public companies, these rules are likely to shift the calculus associated with the decision to go public or transition to private. If these reporting costs are not faced by private companies, then the option to go or remain public is less attractive. A potential consequence of this rule, therefore, could be that there are fewer companies that are subject to the SEC's rules than there would be in the absence of the rule. Thank you.
Thank you, Professor. With that, we will go to Ms. Hermendorfer for your testimony. Thank you.
Thank you, Chairman Huizenga, Vice Chairman Rose, members of the subcommittee. Thank you for the invitation to testify about the Securities and Exchange Commission's unlawful and unprecedented climate disclosure rule. As a native Middle Tennessean, it's a particular honor to be with you here today in Lebanon. I am an appellate administrative law lawyer who recently returned home from Tennessee from Washington, D.C. There, I practiced at a private law firm and had the honor of clerking for federal judges, including then Judge Brett Kavanaugh on the D.C. Circuit, as well as Justices Alito and Barrett. I'm currently the Director of Strategic Litigation within the Tennessee Office of the Attorney General, and General Jonathan Scrimetti is thrilled to have you all here and have the office represented here today. In my role, I primarily focus on pushing back on this bevy of administrative rules we see raining down from Washington, D.C. that harm Tennessee as a sovereign and our citizens. SEC's misguided climate disclosure rule is just the latest example. It inflicts real harm on Tennesseans, and I look forward to discussing that today. The rule has many legal flaws. The Commission's unlimited conception of its own power to mandate climate disclosures violates the major questions doctrine, as you pointed out, Chairman Huizenga, as well as the First Amendment. The Commission's justifications for its sweeping mandates preferences the wishes of ESG activists over Main Street investors who only want to know the information that is material to a company's bottom line. And the Commission's flawed process hampered the ability of commenters to meaningfully vet the agency's proposal and the data on which it was relying. Now, Chair Gensler and many in the media want you to believe that this is a modest compromise rule. that is in line with the SEC's historical powers. Don't be fooled. It's true that the removal of Scope 3 emissions is a major victory for this subcommittee and the many people who pushed back on Scope 3 at the rulemaking stage. But it's critical to remember that the proper baseline for assessing SEC's rule, its burdensomeness, and its legality is not the SEC's wildly out-of-bounds proposed rule. It's the current regulatory status quo. If I tell my daughter that she's grounded for a year and then change my mind and make it 6 months, she's still good and punished. And that's what's happening to industry and investors right now with this final rule. Nor should SEC's gestures towards materiality in the final rule lead anybody astray. As dissenting Commissioner Pierce noted, while the Commission has decorated the final rule with materiality ribbons, the rule embraces materiality in name only. The SEC's rule is not an isolated overstep in the field of business and climate regulation. President Biden's first 18 months in office saw a 75% increase in major rules over and above the Trump administration during that same period. As my written testimony highlights, many of these rules push the envelope to promote an expansive climate agenda. Not even our household appliances are safe. These rules undermine efforts of pro-growth and pro-consumer states. Tennessee has positioned itself as one of the nation's leaders in adopting economic policies that allow businesses and citizens to prosper. But by enshrining burdensome business-harming rules, SEC and other agencies can stymie or even nullify state-level policy choices while cutting states out of the political process, as Congressman Ogles pointed out. All of this is coming at a time when Tennessee and other states have made significant strides in reversing misguided climate policy that harm mainstream investors. In Tennessee, we filed a first-of-its-kind consumer protection lawsuit against BlackRock for its flawed ESG policies. After we did that, BlackRock announced it was rescinding and stepping back from the controversial Climate Action 100+ group that promotes a net carbon neutral zero agenda to the detriment of shareholders and the value of their investments. Vanguard and other companies have likewise retreated from collective promises to fulfill dubious climate-related goals after states' attorneys generals have called them out. These companies realize that a climate agenda and their fiduciary duty to increase shareholder value often conflict, and it's very troubling that the SEC in the final rule relied on policies that these investors have walked back as a basis to justify the sweeping disclosures. Tennessee and other states have mobilized swiftly to fight this rule. We filed a lawsuit along with Ohio and Kentucky in the U.S. Court of Appeals for the Sixth Circuit. Many other states have done the same across the country. Through this and many other cases we are currently pursuing against the administration, we are working towards pushing back on this arrogation of power by federal agencies and to protect the rule of law and our citizens. Thank you for having me.
Thank you, and we appreciate that. And I will note that this is probably one of the most thorough written statements that we've seen. It is notated like you have not, can't believe. But I think that underlies the seriousness. And by the way, we're going to go into member questions, and I'm recognizing myself for 5 minutes. But I'm glad you quoted Hester Peirce. Decorated by materiality ribbons is one of those things that has been, I think, an underscoring of what I have been saying. I always say, and being a former realtor, knowing the three most important things about real estate is location, location, location. The three most important things about disclosure is materiality, materiality, materiality. And I think that is something that we have to be very cognizant of. You mentioned, this is to you, Ms. Hermendorfer, that you had mentioned the major questions doctrine and whether the SEC has the authority to implement climate disclosure regulation. Do they have the authority to require disclosure of climate-related information either through the Securities Act or the Exchange Act as you've done the research?
I think one of the best places to start with answering that question is what the SEC itself has said in the past for 50 years. it has said it does not have the power to mandate kind of across the board climate or other social issue disclosures in its power as a securities regulator. Now, SEC points to language that gives it, the ability to mandate certain disclosures in the context of registration statements and the like, and it points to language saying it has, the power to require disclosures that are appropriate for the protection of investors.
On that note, I mean, have they proved that any of those changes to the materiality standard won't be harmful to investors?
They have not, and there's a number of problems here. So first and foremost, that language they're quoting is clearly tied to other express categories of information that the SEC is allowed to mandate disclosures around. All of that information relates to kind of business books of companies. And so they're trying to fit a square peg in a round hole. And even though there's general language, you can't just pluck out one sentence out of context. But to get to that's what the major questions doctrine helps confirm. You can't use a generalized language to enshrine this type of just industry-altering regime without express, that's just not how we think about Congress empowering agencies. But no, they have not proven that the alteration of materiality is going to further investors. It's actually going to harm them, because the reason for materiality, if we step back and think about it, is companies should be required to disclose things that matter. Otherwise, investors are going to be flooded in information that is not actually probative of a company's value. And by undoing the materiality limit, companies or investors aren't going to be able to decide which of this is actually material to my investment and which is just kind of climate, unrelated climate puffery, for lack of a better term.
Well, some call it greenwashing, some call it a lot of different things. But basically, a flooding of the zone of information renders the information useless, right? Because if there's so much that you can't sort through.
Right, and the greenwashing angle is interesting because SEC is directed at greenwashing, and it mentions greenwashing a number of times. That's fine when you're thinking about the context of a green fund. There are funds out there that market themselves as directed towards ESG investors, and certainly those investors are interested in not having an accurate recounting of what that fund is doing. But you can't then translate that across the board to the average investor who does not hold these kind of climate activist priorities when they're thinking about investing in a security.
So I'm going to move on to Professor Scott. On the second page of your written testimony, I'm going to quote you here. Moreover, vague reporting requirements, which could ultimately be the subjects of lawsuits, will require companies to devote resources to reporting as opposed to action, such as investing in cleaner equipment or funding environmental projects, close quote. I want to focus on the could ultimately be the subject of lawsuits. Have we not seen lawsuits already that have been based on that? I mean, actually, many would argue that that is exactly the strategy behind this, that it's going to be vague enough that there is going to be some left-leaning organization that's going to sue over that, and depending on which circuit court they happen to go into, they are actually going to force change through the court system that way. So expound on that a little bit.
Yes, so there already are lawsuits out there, example lawsuits. A large national air carrier has been sued over carbon neutrality claims. A large food manufacturer has been sued over carbon neutrality claims. So yes, this does open up the possibility of lawsuits. I think that is probably one of the strategies behind it. And that adds to the complexity of how do you do this accurately. It kind of ties into your greenwashing question. Are you accurately representing your data, or are you not accurately representing your data? There's a lot of vagueness there. There's a lot of room for interpretation, and that just naturally invites lawsuits, which almost surely will start to occur.
Okay. Real quickly, is this going to help promote companies going public, or is this ultimately going to harm that?
So this would discourage companies from going public because on the decision to go public or private, of course, you trade off the costs and benefits of each. This increases the costs of going public and increases the benefits of being private. And so naturally, that will shift those companies making that decision, some to remain private that otherwise would be public.
Ms. Jones, I want to finish up with you, and I appreciate you being here. I actually had the privilege of welcoming a constituent of mine, Bill Schultz, to a hearing in Washington, D.C., Their family primarily raises apples, but they also do grapes. They do a lot of other specialty crops. And he talked about the impact. One of the things that we talked about beforehand, and something that Bill had brought up, was the compliance department. Well, the compliance department for your organization, as I understand, is
Me.
you. So even with 210 employees and all the things that are going on, that is a huge burden on that on your operation, is it not?
Yes, absolutely. And I would not feel confident going into this with the limited knowledge that I have on greenhouse gases and what all that, the 7 gases, what they're composed of and what products we have that we would have to do that. So we would have to hire external help for this one.
And you were running me through some of the logistics, measuring inputs on the boxes and the crates that you use to ship your produce, the pallets that are there. You already have some regulations that are on that. And no, you are not going to be excluded because you've got a business that you send these tomatoes to, publicly traded, Publix and Subway and other end users that have that. So even though the word Scope 3 is not specifically in the final rule, we have a great quote from Commissioner Crenshaw, who said at that time that she believed it was a missed opportunity. And her belief is that Scope 3 is invaluable to investors, and her quote was, quote, "Rolling back provisions in the proposal is a missed opportunity. It remains her greatest hope that a future commission will rise to the occasion and enact more fulsome disclosure requirements." And I will note that Chairman Ginsler's statement said we are not requiring Scope 3 emissions disclosures at this time, close quote. I've equated it to, that's a little like saying, well, I'm not going to take both legs out of the economy. I'm only going to take one leg out of the economy, but don't you feel better about that? So ultimately, just give you the last moment here, what do you think this could do to not only your specific business, but to the industry?
I think as a whole to the industry, you will see a lot of, if not all of your small farms say, I've had enough. We can't do this anymore. It's not, you don't want to lose what you have. And it's just going to be hard to continue to maintain the family farms with more of a rule like this.
At which point it pushes it further offshore.
Absolutely.
Yep. Okay. I've gone well over my time. I'm going to be very generous with this, but Mr. Rose, you are recognized for 5 minutes.
Thank you, Chairman Huizinga, and again, thank you for holding the hearing here in Tennessee, and thank you again to our witnesses for being with us. Ms. Jones, I want to pick up on a point that I made to Mr. Schultz when he testified before the committee, or a question I asked him, and I think it's appropriate to pick up here. If Scope 3 was implemented, or if you had companies that you sell to or that supply you come to you and ask about your greenhouse gas emissions, and you had to secure the expertise that you've indicated you would likely have to secure, of course, you will just raise the price of your tomatoes to fully recoup any of those costs. Is that an accurate assessment?
Yeah, right. We are. I always say, and I think it's a term that's been coined across the ag industry. We are price takers, not makers. So we don't get to set our price at all. In fact, our California has a lot to do with the produce industry and what price we pay. They set that market.
Thank you, and I wanted to make that point, and so thank you for making it so clearly. And that's true not just for agricultural producers, but for many small businesses that are, market participants that don't have oftentimes the luxury of just setting their prices. And so when the government imposes regulations like this, it puts them, these businesses, in the awkward position of having to figure out how to pay for the cost of the compliance. Shift gears to General Hermendorfer. The state of Tennessee manages a significant amount of assets for public workers and retirees throughout the state. The managers of these funds have an obligation to beneficiaries to maximize investment returns over a long period of time and to avoid using state pension plans as vehicles to drive social or political agendas. As far as you are aware, has the SEC ever reached out to the state of Tennessee to discuss the obligations owed by Tennessee to pensioners and how efforts such as the SEC climate disclosure rule would affect the performance of companies that pension plans in Tennessee invest in?
So I've not been a part of any of those discussions. I would say, the rulemaking process, SEC purported to get feedback from states and others, but what you really comes through pretty strongly when you look at the justification for the rule is SEC is really allowing places like BlackRock and other kind of climate activist groups to drive the train in a way that is not reflective of what the normal investor cares about, and I think puts those aims over, like you said, the duty to just maximize value. When people put their money in funds and when they buy stocks, they want to see a return. And the other climate things are often undermining that ability.
I agree, and frankly, I'm gravely concerned that the SEC has not considered the impact of this rule on retirees at all, and I fear that, and investors more generally, and I fear that this rule will harm the ability of Americans to retire and receive pensions, and I think ultimately really brings into question or allows those who have a fiduciary duty to perhaps sidestep their fundamental fiduciary duty to receive maximum returns for the funds that have been invested with him. Do you share that broad concern about the impact of this rulemaking?
Absolutely. As I mentioned in my opening remarks, we are seeing a pivot point where some of the actions of this committee and of states' attorney general have started to turn the tide on some of these ESG initiatives and started to beat them back successfully. We've seen Vanguard, BlackRock, many others pull out of these groups. And right at this precise time we're seeing progress, this rule is going to drive all of the energy and compliance and personnel back towards the climate agenda. And as you all know, personnel is policy. And when you have to set up enormous compliance apparatuses around ESG, that's going to be the focus, not fiduciary value.
And to just stay a moment on this question of the impact of the rule and to really kind of drive home the point of the touchstone for disclosure by public companies historically, it's been about materiality. And in this case, the rule is essentially pronouncing that this is material and not leaving it to the companies that are making these decisions about whether an issue is material or not. Could you speak to how that might confuse investors going forward, perhaps giving them more information than they need and perhaps obscuring critical material information that might otherwise come to the attention of investors?
Absolutely. I would commend to this committee the Liberty Energy's brief in the case the chairman mentioned about the stay of the Fifth Circuit. In that brief, they attach a 10-page chart to their brief that explains all of the ways the SEC is playing games with materiality. And just to name a few, the costs related to severe weather events that are subject to disclosure expressly does not have a materiality limit. So there, right there, is just a bevy of information that on its face is not material to investors. They then play games with things like the business uses this as a material factor in evaluating a component of the business. That's not materiality. Materiality is a significant likelihood that a reasonable investor would view this as material to whether to invest. It's not whether a business uses certain inputs to some small segment of its operations. So I would commend that chart to you all as more detailed on all of the way materiality is being undermined. And like you said, it floods investors with information they do not need, and it's hard enough to pick the right investment. When you have to wade through all of this extraneous information, it makes it even harder.
Thank you. Dr. Scott, despite the elimination of Scope 3, I am still concerned that aspects of Scope 3 have been essentially backdoored into this rule. The finalized SEC climate disclosure rule states that companies may request information from their supply chain if a company believes it is exposed to climate risk originating from their supplier. Is that your understanding?
Yes, that is my understanding.
And so, follow up with Ms. Jones. Based on that answer, you could have some of these companies that supply your farm to reach out to you and ask you for this data. As you mentioned in your opening statement, your farm does not have the capacity to provide that information. Is that correct?
Yes, that is correct.
And so, Dr. Scott, is it fair to say that in the case of Ms. Jones and her farm, farms like hers, they risk adverse, they risk the potential that risk-averse companies may choose to just completely cut them out of their supply chain in a fear that they may not be able to provide that data when it's needed?
Yes, certainly. As with any rule and regulation, there's generally a big fixed cost often associated with that, which is bad for small companies because they can absorb those fixed costs. And so larger companies will generally have better reporting capabilities. And if the small companies do not have those reporting capabilities, then companies worried about not being able to report, say, Scope 3 emissions or whatever they're being asked to report would then avoid those smaller companies. So this certainly could have an adverse effect on smaller companies.
And indeed, Chairman Gensler and the SEC actually in the proposed rulemaking suggested that that would be an appropriate action for companies, public companies to take, is to change their suppliers if they could not provide the information. So it is, in my view, a very real risk. Thank you, Mr. Chairman. I yield back.
Gentleman yields back. The other gentleman from Tennessee, Mr. Ogles, is recognized for 5 minutes.
Thank you, Mr. Chairman. Innovation and freedom are byproducts of a healthy and competitive free market. The American success story has nothing to do with government regulation. It has everything to do with the relentless spirit and unparalleled work ethic of the people we're privileged to represent, like our small farmers. In Chairman Gensler's pursuit of an aggressive rulemaking agenda and obsession with climate, the SEC has finalized a climate rule leaving immeasurable burdens on stakeholders throughout the country. Ms. Jones, you are already required to comply with Department of Labor, USDA, EPA, so on, by way of regulations. You know, in short, more regulations, is it fair to say, result in increased costs?
Yes, it is.
And for your industry specifically and broadly across ag, most of your pricing is fixed in large part by California. Is that fair?
That is fair.
So your costs go up in a market where your prices are fixed. Is this going to hurt your profitability?
Absolutely.
Under these circumstances, by these rules and burdens placed upon you by your own government, do you foresee a scenario where small farms like yourself and others across the country are forced out of business?
I absolutely do. I think that as time goes on, it's going to be, even though, like you said, we are resilient people and we fought through a lot of regulations already, but something like this is really going to cause you to stop and take pause.
You know, you've had, Mr. Chairman, we see an increased hostile world where Russia's advancing aggressive in Europe, China against Taiwan, where we have a government that's forcing us to be more dependent on our adversaries. You have Governor Kristi Noem out of South Dakota who says that food security already is a national security issue. And yet we have a government that's undermining our own Constitution, our own sovereignty, our own republic. Mr. Scott, the SEC, absent any congressional authorization, is putting significant burdens on businesses, agriculture across the country. You know, considering the inconsistency of the data, the inputs, I've always, kind of ascribed garbage in, garbage out. How reliable is any of this data that's being collected?
Well, yes, right now it's in a very early stage for many of the different aspects of companies' operations. And I've had many conversations with, I'd say, dozens of companies at this point. How do you do this? How do you get this data? What's the proper way to do it? And it's always worried about doing it an approved way, and that ties back to try to avoid some type of litigation or some type of lawsuit because you want to do something that's, say, approved by the EPA or something. And so, yes, the data is, in early stages. Something as simple as logistics hubs, as I said in my statement, have not really been accurately measured by leading organizations that have been around for almost a decade. So it's hard to get this data. Companies are working on it and devoting resources to it, but it's difficult to get that data.
And so, to summarize, there's not a set standard by which any company, large or small, would be say, oh, we're going to use that standard to collect the data?
There is nothing that is extremely straightforward that companies can follow. There's a lot of gray area that people are trying to work through and understand what the best way to do it. But no, there's not some extremely clear roadmap to follow.
And so if you're a company, whether large or small, you should be horrified that the government's going to come knocking at your door and say, oh, by the way, you did it incorrectly. Meanwhile, they didn't tell you how to do it. Is that fair?
That would be a fear, sure, yes.
Ms. Hermendorfer, do these rules violate the First Amendment or imply any public policy concerns by compelling companies to disclose information that is not intrinsically linked to their financial performance?
So this actually builds on your exchange with Professor Scott. The First Amendment protects the right to decide what not to say, as well as the right to decide what to say. So in the context, that applies in the context of commercial disclosures, as we have here. To justify compelling this type of speech, the government has to clear a high hurdle. It has to show that this is materially advancing a substantial government interest in a way that is no broader, when we think about burdens, than reasonably necessary. And the rule fails any number of those requirements. Because there is no reliable data and companies are going to be having to guess at this, it's not plausible argument by the SEC to say disclosure of this kind of apples to oranges under theorized data is going to meaningfully help consumers, so that they fell prong one of the First Amendment test. On the back end, on the tailoring end, these disclosures are wildly overbroad, even compared to the interest SEC is asserting, and they have not. SEC says some companies are already doing this. That only undermines their First Amendment argument, because the free market is a less burdensome way to allow companies to get investors information when they care about it. And so by mandating an across-the-board disclosure, it does bring up First Amendment violations in addition to Administrative Procedure Act problems.
Well, and then just following up on the broadness of this, you know, if you assume for a moment that these guidelines, these rules are kind of well-intended, although obviously misguided and obviously burdensome to you know, companies and industry, I would argue that I think there's a more nefarious purpose behind it. To Mr. Scott's point of, you're going to have a scenario where the courts are going to be weaponized against the American farmer, against American businesses, because you could drive a truck. They're so wide through these rules. I mean, is that am I a conspiracy theorist by assuming there's going to be lots of lawsuits?
No, not at all. I mean, the fact that you're having to disclose this on a form governed by any number of kind of shareholder regulations and subjects you to suit. We haven't even gotten to the reasonable assurance requirements, where you're going to have to attest that this is, you know, a third-party auditor and all of those types of things. Of course, people are going to sue and say your disclosures aren't appropriate. And I think to the point of this, it's not just a disclosure regime. When you start telling companies they have to disclose things relating to climate that aren't material, what we know is you're trying to drive an end outcome to further the climate agenda.
Mr. Chairman, thank you for being generous with the time. I yield back.
Gentleman yields back. With that, the gentleman from Kentucky, Mr. Barr, who is the chairman of the Financial Institutions and Monetary Policy Subcommittee, is recognized.
Thank you, Mr. Chairman. And let me just first say, Mr. Chairman, thank you for your outstanding leadership in our committee as the leader of our ESG task force, and for exposing the flaws and the problems associated with the politicization of capital allocation. You've done a great job. I have to also say thank you to our hosts, Congressman Rose and Ogles. Thanks for the warm welcome in Tennessee, notwithstanding Kentucky's early exit from the SEC tournament. And Professor Scott, I was hoping for a University of Tennessee, University of Kentucky final. Alas, we'll have to wait to maybe the Final Four or something for that rematch.
Right, yep.
It's okay. He regularly owes me a dinner after MSU beats Kentucky, so that's okay.
But again, thanks for Congressman Rose and Ogles for your warm welcome. Thanks to the Wilson County Fairgrounds and to our witnesses. I love these field hearings because we're in the heartland of America. We're actually with the real people. And sometimes I feel like the bureaucrats, the unelected, unaccountable bureaucrats at the Securities and Exchange Commission need to get out to Wilson County. They need to hear from Ms. Jones. They need to hear from real America, because inundating Americans with trivial, non-material information and disclosures is not in keeping with what the American people want or need. And they need to do a better job listening to the American people. You know, they say they've simplified the final rule because they've jettisoned this very unpopular Scope 3, but maybe not, as Congressman Rose pointed out. But the original proposal was only 534 pages. The final rulemaking is 886 pages. That's the final rule. I don't know how that was a simplification. Nevertheless, when you look at the final rule of any SEC or any regulatory proposal, I think you should look at it from the lens of the statutory mission of the agency. And what is the statutory mission of the Securities and Exchange Commission? It's a tripartite mission. 1, protect investors. 2, facilitate capital formation. And 3, maintain fair, orderly, and efficient markets. So let me ask our witnesses about those 3 statutory goals. First, protecting investors. It is estimated that this rule would increase external costs of public companies by 21% and imposes complex compliance risks. We've heard about the litigation risk. So to Professor Scott, you've cited these competing standards and the lack of clear guidance on the procedures that companies should follow when reporting emissions from the Global Logistics Emission Council, Institute for Financial Reporting Standards, International Sustainability Standards Board, et cetera, et cetera. Will this, all of these competing standards and the complexity of this, will that enhance the ability of public companies to deliver on corporate earnings, or will that divert resources away from financial performance and instead towards compliance and litigation avoidance?
Yes, it clearly diverts costs from and from their financial performance onto compliance costs, collecting data. They're going to have to hire people or hire expertise, such as consulting firms, law firms. The cost will certainly go up in knowing which one they have to comply with, whether it's acceptable from a legal perspective, which you wouldn't even know until a lawsuit occurred. So the costs are certainly imposed on these companies by these type of regulations, and it's in a large degree not value add.
So Ms. Hermendorfer made the point that I think she's citing from the agency itself that the estimated compliance costs would exceed $4 billion. Is that enhancing to investor protection? Does that enhance companies to focus on delivering investor returns, or does it detract from a company's ability to deliver on returns to the shareholders?
Anytime you have a thing diverting from the mission of the company and diverting from innovation and cutting cost, yes, it's going to detract from investability and from considerations around driving shareholder value.
And will the liability uncertainty result in over-reporting or under-reporting?
Oh, absolutely over-reporting. Some of the materiality language, is it reasonably likely to be material in the future? And we're talking about climate events that are unknowable based on data that doesn't exist. So, of course, a shareholder after the fact is going to be able to say, oh, you reasonably should have known, should have predicted the future.
So over-reporting means that more likely than not, there will be immaterial information provided to investors. Is that conducive to maximizing investor returns, or is it likely to result in lower returns for investors?
Anytime you have something detracting from the core mission of the company and what they do and what they make, it's going to decrease value and not add it's going to decrease shareholder value without any attendant benefit to investors. So
strike one, not protecting investors. Point number two, the energy industry. What is the impact on the energy industry? I'm Professor Scott. I'd love for you to discuss how the final rule would alter public institutions' willingness and ability to do business with traditional companies in the United States, like those in the energy and freight trucking industries. Is this really about? Is this rule really about disclosing financial risk or creating financial risk for politically unfashionable energy businesses?
Well, yes, it will certainly impact the energy producers the most because they would have the largest carbon emissions. It also would change the calculus of whether companies do things themselves with their own assets and their own manufacturing plants, or whether they use third parties, or whether they use third parties perhaps offshore or in in another location, because that will reduce their emissions just by accounting, right? Even though emissions don't necessarily decrease overall, it's just an accounting change from going from something they own versus something they don't own. So yeah, certainly energy would be affected probably the most by this.
If the second mission is facilitating capital formation, and the rule would redirect capital away from certain American industries, that seems like strike two, not facilitating capital formation. But final point on fair, orderly, and efficient markets. Ms. Hermendorfer, Chairman Gensler justifies the rule by arguing that the rule would enhance consistency, comparability, and reliability of company climate disclosures. But the final rule, as the SEC has admitted, would allow public companies themselves to determine for themselves what disclosures are in fact material to investors. Further, what one investor may deem to be material, another investor may not. That being the case, would the final rule in fact enhance consistency, comparability, and reliability, or would it just increase confusion in markets?
I think for the reasons Professor Scott mentioned, it would increase confusion without any attendant benefit.
Well, strike three, and I've gone way over time, but I thank the chairman, and I thank my host from Tennessee for your indulgence in letting me go on a little bit longer. I yield back.
Gentleman yields back. I'm going to give a little lay of the land. We're going to go to Mr. Flood next to take his time, and then I'm hoping to do a very brief 2-minute lightning round so that we can go right up to 11:30. We do have a hard stop, if that's okay, with our witnesses. So with that, Mr. Flood, you're recognized.
Thank you, Mr. Chairman. This is a really informative hearing. It's not nearly as fun as last night. Mr. Rose, thank you for your hospitality and for introducing us to everything Tennessee has to offer. Mr. Ogles, great to be here. I'm also grateful that we don't have to deal with the Scope 3 emissions reporting being included within the rule. Had that been finalized, it would have been an unmitigated disaster for the farmers and ranchers of Nebraska. And while that's good news, I'm not sure we're entirely out of the woods, as we've already talked about today. I'd like to return to the state of California and their plans to regulate Scope 3 climate disclosures. California passed, as we talked about, a law late last year that aims to impose these disclosure requirements on businesses based in the state. This is what we see a lot out of California. They're using their size and their state sovereignty to try and push us on the federal level, and certainly the states like Nebraska and Tennessee. That law is going to have an impact beyond the boundaries of California. Let's say you have a farmer right here in Tennessee or in my home state of Nebraska that supplies produce to a restaurant chain with their headquarters in California. Let's think Chipotle or something like that. If the California law is implemented, the Scope 3 reporting obligations, as we've talked, would be passed down to those farmers that help feed the Chipotle customers around the country. It's not that bad if Scope 3 were included directly within the, it's not as bad as had it been directly included with the SEC's rules, but it's still going to have these far-reaching effects. Ms. Hermendorfer, as you have so capably shared this morning, can you update us on what challenges to the California law are pending? What can we do? Where is this going to go? And what should we be telling farmers in Tennessee and Nebraska about runaway legislation in California reaching its ugly hand into states like mine?
So I must confess I'm not fully up to speed on the most recent details, but the lead challenge to the California rule is being pursued by the United States Chamber of Commerce. They're making both kind of state administrative law challenges as well as a First Amendment challenge based on many of the arguments you all are familiar with about the burdensomeness relating to the actual value that California is trying to drive in terms of disclosure. So that case is proceeding in the very capable hands of the U.S. Chamber of Commerce. Beyond that, we've seen the Biden administration kind of, I would say, outsource many of its priorities to California. We see this in the Clean Air Act context when California has a California-specific special waiver where it gets to set emissions that then drive the rest of the market, and that's also being challenged by a coalition of states and the D.C. Circuit Court of Appeals. So it's a troubling trend, and if SEC truly wanted to make uniform these disclosures, you would have thought it maybe would say, California needs to stay in its lane and adopt more of a uniform compliance regime, but that's not what we're seeing. We're seeing Chair Gensler be happy to let California kind of drive Scope 3.
It's really part of a troubling trend. Pork producers in Nebraska, and I'm sure across the nation, are dealing with these new requirements out of California about how a hog confinement can operate, which, if fully implemented, will make it very hard to produce the pork that the Californians want. And I can tell you there are already farmers and ranchers across this country that are saying, we're not going to do business in California because we can't make a living with the requirements they're placing on the food supply. The other issue that I really want to touch on, Ms. Hermendorfer, in your understanding of the final rule from the SEC, does what I'm describing constitute a risk in your opinion? Could the SEC try to use information intended to promote a public company's business practices to argue that Scope 3 disclosures are material? And I think you've already answered this, but can you circle around to that? How can the SEC take those disclosures and bootstrap their argument up that suddenly all this stuff becomes material?
So one of the concrete examples I think you can draw from the final rule is it sets a presumption of materiality to anything that is elevated to the board level. So you have a situation where you could have climate risk discussions occurring at the board that aren't material overall to the company, but under the final rule, there would be a burden put on the company to prove it was not material. So it's flipping kind of what we think about materiality on its head. And certainly that's just one of the many ways I think the rule could be twisted in the way that you mentioned.
Well, the citizens of Tennessee are very fortunate to have somebody so capable in the Attorney General's office, and I'm glad to know you're on the job. So with that, honoring the time requirement, I yield back. Thank you, Mr. Chairman.
Well, with that, thank you. We're going to try to do, we've got about 15 minutes, and we're going to try and do 2 minutes each. We're going to have to try to hold to that. And I will start. And Mrs. Jones, you and I talked a little bit about the soil, the land that you work. So many have this assumption that you're out there and don't really care about the property that you own and the land that you own and the final product. Give us a little flavor of what really you think, and pull that close, Mike, nice and close.
Okay. So I've always said that there are no better stewards of our land than our farmers. Our farmers, that's our livelihood. We have to protect our land. We are very careful about conservation practices, whether it be water or drainage ditches or whatever that might be, to make sure that it is as productive as it can be. We want to make sure that we do cover crops and all of those things to make sure that the soil health is good. So I think that, any perception that the farmers are not taking care of their land and taking pride in what they do as far as the products that we produce. And it's prideful to know that we play a role in the food security of this nation. I'm proud of that. And I think you'll be hard-pressed to find a farmer that's not proud of that. So I think to any perception of that we're not doing what we should do to take care of our farms and our environment and our water is just misfounded.
Thank you for that passionate plea. In the 30 seconds, Professor and Ms. Hermendorfer, if there's one thing that you want us to walk away from today, what is that?
That these rules and how companies can respond and comply with them are very complex and vague and not known, and so companies are devoting a lot of resources to it that is not necessarily value add.
Okay. Ms. Hermendorfer.
Keep up the pressure. Don't let this Scope 3 withdrawal fool anybody about the burdensomeness of this rule.
With that, my time has expired and beautifully said. So with that, Mr. Rose, 2 minutes.
Thank you, Chairman. As we sit here today at this hearing, and as some of you may have noted as you came in the front of this building, we're in the Made in Tennessee building here at the Wilson County Tennessee State Fairgrounds. And if we were here in August, we would see products from all across Tennessee, the 95 counties that you see emblazoned on the floor of this building. There would be examples of the products from those 95 counties. So just in a quick succession across the three panelists, if with this rule implemented, and you've each discussed the implications of it, we live in a time when this country has already a massive trade deficit. And I'm just wondering the impact of this in your estimation. How likely is this rule to positively contribute to the productivity of this country and the reduction of our reliance on foreign suppliers for so many of our products? If you would just each comment on that. Do you think this is going to make America more self-sufficient or less self-sufficient?
Yeah, I would just say it discourages production by things that these companies own. It could encourage outsourcing and shifting overseas to reduce emissions, really just an accounting trick. So I would say it would discourage production.
It will hurt Tennesseans and other investors across the country who have different values than some of those kind of ESG activists on Wall Street.
You know, I've talked about the record keeping that it would cause on our farm. I think it's going to cost the country more money to implement such a rule as well, because I don't know how they're going to manage all of the data that they're asking for. So I think it's definitely going to discourage and not good for Tennesseans at all.
Thank you, Mr. Chairman. I yield back.
With that, gentleman, Mr. Ogles is recognized for 2 minutes.
Thank you, Mr. Chairman. Thank you to our witnesses. To expand on Mr. Flood's point about our AG's office, I'm going to kind of settle in on you, Ms. Hermendorfer. You know, I too am glad that you're on the job and that our AG is on the job. The governor did a great job of working with Supreme Court and picking Scrimeti, and the work that you guys are doing, your teams are doing, and really putting Tennessee on the map as far as leading this charge for the 10th Amendment against the federal government. If you may, just highlight some of the things that your office is doing to, again, put Tennessee at the forefront of pushing back against the federal government.
Well, the state legislature generously funded a new strategic litigation unit that I'm honored to be a part of. And through there, we are in well over a dozen lawsuits against the administration right now, 3 or 4 in the EPA context. There's an ESG ERISA investment rule we've sued against. We've prevailed against a dishwasher regulation that was recently set aside by the Fifth Circuit. We are preparing to litigate any number of rules that are currently coming down the pike for the spring. In the context of business and climate, you know, we've pushed back by suing BlackRock, and that case is ongoing. That's only kind of in the sphere of environmental climate. We have many other cases where we are trying to vindicate the interests of Tennessean and kind of social issue areas like abortion and other cases like that.
Well, just know that the committee, we're here as an asset. If there's any advice that you have or things we should be doing, please reach out to myself or any of my colleagues. Mr. Chairman, I yield back.
Gentleman yields back. With that, gentleman from Kentucky, Mr. Barr.
Well, let me join in the echo of praise for the Tennessee Attorney General's office and Ms. Hermendorfer for being on the job. One final question for you. And I'm glad Kentucky has joined Tennessee in some of those lawsuits. Chairman Gensler makes the argument that the SEC-directed disclosure mandate is needed to substantiate public companies' emissions reduction claims. And he says that the agency has, quote, broad authority to promulgate disclosure requirements that are necessary or appropriate in the public interest or for the protection of investors. Can you elaborate on your point that the SEC has for decades disavowed the authority to mandate across-the-board social and environmental disclosures, expand upon this lack of statutory authority and the major questions doctrine?
Absolutely, thank you. There was a a big debate around SEC's power in 1975, and the agency itself concluded it did not have the statutory authority to mandate across the board what it called social issue disclosures, of which this is one. So flash forward to 2016, the agency again reiterated it generally, its investor protection mandate and the statutory provisions it cites are relating to the business's bottom line. And certainly, as you mentioned, if a company is making claims about its emissions disclosures that are material to its business or to investors, those are already regulated by current regulations. That's another word for that is securities fraud, right? So we don't need these additive disclosures that don't further move the ball for investors to understand what companies are doing. So that undermines the rule both from a First Amendment perspective and from a statutory authority perspective.
I yield back. Thank you.
Gentleman yields back, and gentleman from Kansas, Mr. Flood, 2 minutes.
Thank you, Mr. Chairman.
Sorry, Nebraska. I put you in the wrong state.
We came in at the same time, Kansas-Nebraska Act, so it's fine. Let's see, we have Ms. Jones and Professor Scott. One of my concerns, you can talk about materiality, if you're raising tomatoes or corn or beef or pork or whatever it is in the state of Tennessee, or you're running a supply chain network here in the southeastern part of the United States, do you think that the people you work with realize how under threat they are from some of these rules that are happening? And by that, do the men and women of agriculture in Tennessee know how important it is for them to start paying attention to all of these different efforts on the environmental, social governance front that could threaten their very way of life, their business, their farm, their family? Ms. Jones, you're in agriculture. Do your colleagues in agriculture realize that what the SEC is doing? They're not used to paying attention to the SEC. They're used to paying attention to the USDA. But there's a big threat looming. Is agriculture ready for this? Is agriculture up to speed on what's happening?
I would love to say yes, but I'm afraid that's probably not accurate. You know, it's not something that's always on our, I don't pay attention to what the SEC does, but until recently when I figured out that this was, that they were looking at the gas, the greenhouse gas emission, then I started paying attention. I think Farm Bureau in our state does a really good job trying to keep us up to date on everything that's going on legislatively, but I don't know that some of the smaller growers really, if they're not really involved in the Farm Bureau, I don't know that they necessarily will be aware of what's getting ready to happen to them.
Professor Scott, real quick.
Yes, people are certainly waking up and becoming aware of that. And I think it's starting to the point where there's confusion at this point, but they are aware that these rules are coming. Now the question is, how do you comply with those types of rules or provide this type of data? I think that's where people are right now.
Thank you, and I yield back.
Gentleman yields back. It's hard to believe an hour and a half has gone by already. This has been fascinating, and I just would like to say again, thank you to our witnesses for your time, your effort to get here, certainly your experience and your expertise, and what we have to go through is we need your input. We need to have a real-world understanding of what is going on. So. Ms. Jones, appreciate your efforts, especially in Feeding America, and making sure that we are self-sufficient. That is a key point I think you hit on at the very end, and Professor Scott as well, and as well as Ms. Hermendorfer. Thank you for your efforts in having that testimony today. So without objection, all members will have 5 legislative days within which to submit additional written questions for the witnesses. You'll do that through the chair, which we will then forward to our witnesses, and we ask our witnesses to be able to please respond as promptly as you are able. And with that, again, I want to say thank you to my friend Mr. Rose and my friend Mr. Ogles for helping to put that together, for the staff all across the board for your efforts in making this happen. We think this is, as Mr. Barr pointed out, this is an important thing to do, to go outside of the Emerald City outside of, I often refer to, I'm going to the land of Oz to a number of my constituents. We've got to get outside the Emerald City and actually see what is happening in real America. And I wish we could drag a few of our regulators along with us on a few of these hearings, but we are doing the best that we can. So with that, again, thanks for everybody for being here, and with that, we are adjourned.